Welcome to the deep dive. Today, we're really plunging into a major story. It's been generating a lot of headlines, a lot of talk. I'm talking about the $260 million sexual assault and harassment lawsuit filed against Tyler Perry by actor Derek Dixon.
Huge numbers, huge names involved.
Exactly. And look, this isn't just about, celebrity headlines. We want to go much deeper today.
Yeah, definitely.
Our mission is really to unpack the allegations themselves, get a handle on the legal definitions, what is sexual harassment legally speaking,
Right.
and explore what kind of evidence is actually crucial in these kinds of cases. And then think about the broader implications, for workplaces, especially in powerful industries like entertainment.
Absolutely. Our goal today is really to, cut through some of the noise, maybe, and just deliver a clear understanding.
Yeah.
We'll look at the claims, Perry's defense, the legal framework around it all. We've pulled from, all sorts of places, the legal filings, news reports, even some public commentary, just so you get a really well-rounded picture.
Yeah.
But it's important to state, while we're drawing on these sources, our job here is to present the information impartially.
Right. No endorsements.
Exactly. We're not endorsing any specific viewpoints, especially, some commentary out there can be pretty judgmental or off topic even.
Gotcha.
We just want to lay out the facts as reported so you can be genuinely well informed on what is, let's face it, a pretty complex topic.
Okay, makes sense. So let's dive right in then. The heart of it. Derek Dixon's lawsuit against Tyler Perry and his production companies.
That's TPS Production Services, LLC, and Action, LLC.
Right. Filed June 13th, 2025, Los Angeles Superior Court. And that figure seeking $260 million.
It's a massive sum. And the core of the complaint alleges what Dixon calls a sustained pattern of workplace sexual harassment, assault, and retaliation.
Sustained pattern. Okay.
Yeah. And the suit claims Perry used his, quote, considerable influence to create this coercive, sexually exploitative dynamic. That's the language used.
Okay. Coercive and exploitative. And a big part of this seems to be the quid pro quo element, right? This for that.
Exactly. Dixon claims Perry allegedly dangled career opportunities, producing Dixon's pilot script, casting him in show.
Big opportunities for an actor.
Huge. But the lawsuit alleges these promises were tied to Dixon enduring escalating harassment and retaliation when Dixon didn't reciprocate what he calls unwanted advances.
So the advancement was conditional on something else.
That's the allegation. And you can sort of trace this alleged pattern from the start, according to the complaint.
How so?
Well, it mentions an initial meeting, September 2019. Perry supposedly notices Dixon at an event, recruits him, they exchange numbers.
Okay.
Soon after, Perry offers him a role in the show, Ruthless, maybe hinting it could grow into something bigger.
Setting the stage, potentially?
Potentially. Then alleged early sexualized comments. There's a specific example mentioned. A text from Perry after seeing Dixon's Halloween costume.
What did it say?
Something like, your cowboy needs a sugar daddy.
Wow. Okay, so that's pretty direct, if true.
If true, yes. It suggests, according to the suit, an attempt to establish a particular kind of dynamic very early on.
And did it stop there? The lawsuit suggests it escalated.
It definitely alleges escalation. Claims Perry started buying Dixon gifts, like a new car, but also demanding attention through constant texts and calls.
So gifts, but also control.
That's the implication.
Yeah.
Then there's an alleged text on New Year's Eve 2019 where Perry supposedly stated he hadn't had good sex since becoming rich.
Okay. And then actual alleged physical incidents.
Yes. The first alleged assault, described as January 2020, Dixon was invited to Perry's home in Douglasville, Georgia.
Right.
The suit claims Perry got into bed with Dixon, who was apparently just in his underwear, and rubbed his inner thigh.
Okay.
When Dixon reportedly pulled away, Perry then allegedly asked to see him naked and made comments about his body.
Yeah. And then the connection to his work, his roles.
This is where it gets particularly detailed. Dixon was cast in The Oval, his character Dale, written as gay, homeless.
Okay, and by the end of the season, the character gets shot 4 times.
Wow.
And the lawsuit claims Perry explicitly told Dixon that the character's survival, whether he lived or died on the show, depended on Dixon keeping Perry happy.
Seriously?
Allegedly, yes. And being loyal or obedient, implying he'd just kill off characters if actors didn't comply with his wishes.
That sounds like a direct threat related to his job, linking survival on the show to personal demands.
That's exactly what quid pro quo harassment often looks like. This alleged link between job security or advancement and submitting to demands.
And the alleged physical stuff continued too.
According to the complaint, yes. March 2020, at Perry's Atlanta home this time. Perry allegedly asks Dixon if he liked it rough and red.
Okay.
That allegedly grabbed Dixon's throat and supposedly said, "Wow, look how excited you just got. You do like that."
That's incredibly aggressive if true. Paints a picture of a really coercive environment.
It does. And the control allegedly extended even into the pandemic lockdowns. April 2020.
How so? Dixon claims Perry would coerce him into drinking during calls, which then turned into sexually explicit rants, complaining Dixon wasn't giving him what he needs, and allegedly warning Dixon specifically not to tell other cast members about the harassment.
Isolating him.
That's often part of the pattern of these alleged situations.
Yeah.
Isolation and control.
And on set, did it continue there?
The suit alleges it did. Throughout 2020, filming a, quote, tirade of comments. Things like asking if he liked being choked, questions about his body, calling him thick Derek, commenting on his ass and thighs.
So constant commentary.
Allegedly. Questions about his sexual preferences, like top or bottom. Perry also allegedly revealed personal details, saying he has sex with men and identifies as a top.
Okay.
The suit even claims Perry took photos of Dixon's buttocks and sent the pictures.
That's a lot. It's a lot to take in. These details are painting a picture of really sustained, alleged harassment.
And it allegedly culminates in more serious incidents. There's the trailer incident near the end of The Oval, filming in 2020.
What happened then?
After Dixon's character was shot on the show, Perry allegedly invited him to his trailer. Asked him point blank, "Are you attracted to me?"
Okay.
Then allegedly pinned Dixon against a wall and aggressively groped his buttocks.
Groped him, okay.
And then there's an alleged incident on a trip to Perry's private island in the Bahamas in October 2020.
A cast trip.
Supposedly. So, there, Perry allegedly forced drinks on Dixon, talked about wanting a non-emotional sexual relationship, praised Dixon when he was greased up.
Grease up.
Yeah, like with lotion or oil, presumably. And then, again, allegedly aggressively groped his buttocks.
So repeated alleged groping incidents.
That's what's claimed. And then the most serious alleged physical assault mentioned is from June 2021.
What does the suit claim happened then?
It alleges Perry pulled off Dixon's clothing, groped him again, and actually attempted to force himself on him sexually.
Right. And after that alleged assault, what happened?
According to the lawsuit, Perry apologized profusely afterwards, blamed alcohol, said he was self-sabotaging.
Okay, an apology.
But then, almost immediately after, allegedly told Dixon, "We're going to do your show."
The pilot script he wanted to produce.
Exactly. That specific sequence, alleged serious assault, followed by apology, followed immediately by a career promise that looks very much like the alleged quid pro quo dynamic again.
Linking the promise directly to the aftermath of the alleged assault.
That's how the suit presents it. But the alleged manipulation didn't stop. In April 2022, Perry supposedly lectured Dixon.
Lectured him? About what?
Allegedly blaming Dixon for the sexual assault, saying Dixon needed to say no stronger.
Wow. Victim blaming.
Essentially, yeah. Implying Dixon's no actually meant yes, which is a common disturbing tactic in shifting blame in abuse dynamics.
And what about that pilot losing it? Did it ever get made?
No. And Dixon claims Perry never intended to make it. He alleges Perry bought the rights just to string Dixon along.
Keep him quiet.
And control him, yeah. Especially the suit notes, because Perry was apparently under a contract with Viacom CBS at the time that would have prevented him selling the pilot for 2 years anyway.
So the promise itself was potentially hollow from the start.
That's the allegation, that it was purely a manipulation tactic.
This is just disturbing. And there's more. About the show itself.
Yeah, this is striking, if true. In a later season of The Oval, Dixon's character, Dale...
Who had been shot 4 times.
Right. His storyline was apparently changed so the character became a male prostitute.
Seriously?
And the lawsuit claims some of the lines written for the character directly mirrored private conversations Perry allegedly had with Dixon.
That feels almost like adding insult to injury. Writing his alleged experience into the show.
It could certainly be interpreted that way, and if true, it could serve as powerful circumstantial evidence in court, potentially.
Now, we have to mention Tyler Perry's response, right? His legal team.
Absolutely. His attorney, Matthew Boyd, has come out strong. He called the allegations a scam and fabricated claims.
Fabricate, okay.
And stated very clearly that Perry will not be shaken down. So a very firm denial.
Okay. And connecting this back, Dixon did try to report this formally.
He claims he reported Perry's conduct to the EEOC, the Equal Employment Opportunity Commission, back in 2024.
And what happened then, according to the suit?
The lawsuit alleges that Perry and his studios failed to investigate or take any steps to prevent further harassment.
So inaction.
Alleged inaction, yes, which Dixon claims led him to eventually quit the Oval, even though it meant losing out on significant income, nearly $400,000, the suit says.
He quit, and was that the end of it?
Not according to the lawsuit. It alleges retaliation followed. Perry's team supposedly told Dixon to tell people his departure was for a medical leave.
A cover story.
Seems like it.
Yeah.
And then that medical leave was allegedly made unpaid.
So alleged reporting, alleged inaction, quitting, and then alleged retaliation.
That sequence is often a critical part of harassment and retaliation lawsuits. It builds that picture of alleged systemic failure and punitive action.
Okay, so we've laid out the timeline, the specific disturbing allegations. Now, the big question, how do you prove something like this in court?
Yeah, that's always the challenge, isn't it? Especially since, as legal experts always point out, most harassment happens covertly, behind closed doors.
Not usually in front of a crowd.
Exactly. So it often comes down to circumstantial evidence. But it's crucial to understand juries are instructed to weigh circumstantial evidence just as heavily as direct evidence.
Okay, so it's not necessarily weaker.
Not necessarily. Think of it like seeing wet footprints leading away from a swimming pool. You didn't see the person get out, but the footprints are pretty strong evidence they were just in the water, right?
Right. You build a picture from the clues.
Precisely. It's about building that credible picture for the jury.
So what kinds of evidence are generally seen as helpful? What do legal experts say helps prove these claims?
Well, first off, just your story, your truth matters, even if it feels like it's just your word against theirs. He said, she said. A good lawyer can often build a case by corroborating details, showing consistency.
Okay, so the testimony itself is key.
Absolutely. Then, perhaps most critically in the modern age, the paper trail.
Texts, emails.
Exactly. Texts, emails, messages on work platforms like Slack, maybe even social media messages. Any written or recorded evidence can be huge.
Even if it's not explicit.
Yes. Even things like repeated unwanted dinner invitations via email or work emails being ignored after someone rejects an advance. These can show a pattern of unwelcome behavior or potential retaliation.
Okay. What else?
Correspondences with others. Did you confide in anyone at the time? Coworkers, friends, family.
Does that count as evidence?
It can, yes.
Yeah.
Especially if those people can testify about what you told them and when. Also, talking to medical providers.
Doctors, therapists.
Right. If the stress manifested physically or mentally and you sought treatment, those medical records or testimony from the provider can be powerful evidence of the impact. Keeping a contemporaneous journal is also highly recommended.
Documenting things as they happen.
Exactly. And then there are witnesses and Me Too victims. Are there other people, current or former employees, who saw the behavior or experienced similar things themselves?
Strength in numbers, potentially.
It can definitely show a pattern of behavior, which makes the claims more credible. Sometimes lawyers will even research a company's litigation history to see if there have been similar lawsuits before.
Okay. And what about the employer's role?
Crucial. Evidence showing employer knowledge and inaction is vital. Did you report it? Did you resist? Did you object?
How do you prove you reported it if it was verbal?
That's tricky. While verbal complaints are legally valid, say in California, written complaints, emails, formal HR reports are always better for creating that undeniable record.
Right. Documentation, again.
Always. And there's something called strict liability we should mention.
What's that?
If the alleged harasser is a supervisor, the company can sometimes be held automatically responsible, strictly liable for their actions.
Even if the higher-ups didn't know?
In some situations, yes, because the supervisor is acting with the authority the company gave them. It highlights the responsibility companies have for who they put in power.
That's significant.
It is. Also important is documenting how the employer responded, or failed to respond, if you did complain. Did they investigate properly? Did they take meaningful action? Failure to do so can show the company essentially condoned the behavior.
Okay. Any other evidence types?
Yes. Keeping good records of your job performance.
Your performance reviews and things. Why?
Because often when someone complains about harassment, the alleged retaliator might suddenly claim the person was a bad employee.
Try to justify firing them or demoting them?
Exactly. Having solid performance reviews, emails praising your work, things like that, directly counters that narrative. It helps show the real reason for any negative action was likely the complaint, not performance.
That makes sense. Protect yourself.
Right. And all of this really underscores what a legal analyst pointed out regarding this case. text messages, like the ones heavily alleged in the Dixon lawsuit. They can be potential smoking gun evidence.
The receipts.
Exactly. They can provide concrete proof that moves the case far beyond just he said, he said.
Okay, that's helpful context on evidence. Now let's zoom out a bit. How is sexual harassment actually defined legally? What are the official definitions, say, from the EEOC?
Right. The U.S. Equal Employment Opportunity Commission, they define unlawful harassment pretty clearly.
Yeah.
It includes things like unwelcome sexual advances,
Okay.
requests for sexual favors.
Quid pro quo type stuff again.
Can be, yeah.
Yeah.
And other verbal or physical harassment of a sexual nature. But it's broader, too. It can also include just offensive remarks about a person's sex in general.
So not necessarily sexual in nature, but derogatory based on gender, like offensive comments about women generally?
Exactly. That can also constitute unlawful harassment if it creates a hostile environment.
Okay. And are there other key points in the definition?
Yeah, a few important nuances. Both the victim and the harasser can be any gender, and they can be the same sex. That's important.
Okay.
And crucially, the harassment becomes illegal when it's either so frequent or severe that it creates a hostile or offensive work environment.
Frequent or severe, that's the threshold.
That's the key legal standard for hostile environment claims. Or if the harassment results in an adverse employment decision.
Like being fired, demoted, passed over for a promotion.
Exactly. Being fired, demoted, losing pay, getting undesirable assignments. That's the other way it becomes illegal harassment.
So it's not just about simple teasing or like isolated incidents that aren't super serious. Those generally don't qualify legally?
Generally, no. The law recognizes that workplaces aren't always perfectly polite. It's when the conduct crosses that line, becomes frequent enough or severe enough to fundamentally change the conditions of employment, making it hostile or offensive, that it becomes illegal.
Got it. And who can be the harasser?
It could be anyone, really. A supervisor, obviously. Even a supervisor in a totally different department. A coworker, or even someone who doesn't work for the company at all.
Like a client or a customer?
Yep. If the employer knows or should know about harassment by a client or customer and fails to take appropriate action, they can still be held liable.
Wow. Okay. And just briefly, who does this law cover, and are there time limits?
Generally, EEOC laws cover employers with 15 or more employees. And yes, there are strict time limits to file a charge, usually 180 calendar days from the day the harassment took place.
6 months, roughly.
Right. Though state laws sometimes provide longer filing periods, sometimes up to 300 days. And for federal employees, the deadline is even shorter, just 45 days to contact an EEO counselor.
Okay, tight deadlines. So if we bring this back to the Dixon case against Perry, you can really see how the allegations fit these definitions, can't you?
Oh, absolutely. The lawsuit specifically includes claims like quid pro quo sexual harassment, work environment sexual harassment based on frequency and severity, sexual assault, and retaliation.
All falling squarely under these legal frameworks we just discussed.
Precise.
Okay, so understanding the claims and the law, what are the stakes here? For Perry, for Dixon, for the companies, we heard the defense strategy is basically calling it a scam.
Right. Perry's lawyer, Matthew Boyd, came out swinging, calling it fabricated claims, saying Perry won't be shaken down. It's a strong denial, aiming to discredit Dixon right off the bat.
A common tactic, you said.
Very common in high-profile cases. But from a legal analyst viewpoint, cases with evidence like alleged text messages, they can be quite strong.
Because of the receipts.
Exactly. Especially for proving that quid pro quo, that this for that. If texts allegedly show Perry linking career help to Dixon's compliance or punishing him for not complying, that's powerful.
What about the timing? The suit was filed in June 2025, but some of the worst alleged incidents, like the guest house assault, were back in June 2021. Does that delay hurt the case?
Not necessarily. Legal analysts point out that victims, especially when dealing with someone incredibly rich and powerful.
Like Tyler Perry.
Exactly. They often don't come forward immediately. There's fear. Fear of not being believed, fear of public scrutiny, fear of career annihilation, actual retaliation.
Makes sense.
And the fact that Dixon apparently started seeing a therapist back in 2020, which the suit mentions, that could actually be helpful evidence showing he was dealing with the alleged impact long before filing suit.
Okay. And that $260 million demand, is that realistic?
Well, in civil cases, lawyers can ask for various amounts. It grabs headlines, certainly. The ultimate decision on damages, if the case goes to trial and Dixon wins, would be up to a jury. They consider actual damages, emotional distress, punitive damages. It could be much less. It could be substantial.
Right.
And it's worth remembering these cases are very often taken on contingency.
Meaning the lawyer only gets paid if they win.
Right. They take a percentage of the settlement or award. This makes it possible for someone without deep pockets to actually sue someone very wealthy. It levels the playing field somewhat.
Okay. So broader picture now. What are the implications here, especially in Hollywood? The lawsuit itself draws comparisons.
It does. It explicitly mentions names like Harvey Weinstein and Sean P. Diddy Combs, situating Perry within that context of powerful men accused of misconduct.
Setting a certain narrative.
For sure. And legal analysts watching this are saying, look, if these detailed allegations against Perry are true, there might be others.
Other potential victims.
It's a possibility. Sometimes one person coming forward empowers others. It can create a kind of snowball effect, which could dramatically reshape public perception and potentially lead to more legal challenges.
Right. So there's this tension, isn't there, between Perry maybe wanting to fight this in court to clear his name.
Absolutely. Defendants often feel strongly about proving their innocence.
Versus the potential PR damage of a long public trial, especially if those alleged text messages, the smoking guns, come out.
That's the calculation they're likely making. Settling might avoid more damaging revelations, but it can also be seen as an admission of sorts. Going to trial is risky if the evidence is strong.
And these things take time.
Oh, yeah. A trial, if it happens, we're probably looking at 2026, maybe even later. These complex cases move slowly.
Okay. So wrapping this up for today's deep dive, what are the key takeaways for you, our listener?
Well, I think we've unpacked the very specific and frankly disturbing nature of the allegations against Tyler Perry by Derek Dixon.
Right. The details are important.
Definitely. We've also seen just how critical things like documentation, texts, emails, journals, and also support systems like confiding in others or seeking therapy can be in building sexual harassment cases.
Yeah, the evidence trail is key.
And we've looked at the legal framework, what actually constitutes illegal harassment, like quid pro quo or creating a hostile work environment.
Understanding the lines.
Exactly.
So maybe a final thought to leave everyone with.
Yeah, perhaps something to chew on. When you hear stories like this, alleging unchecked power and influence, it raises questions, doesn't it?
Like what?
Like, what responsibility do powerful individuals have, not just for their direct actions, but for creating environments where people feel they can't say no? Where saying no might mean losing your job, your career hopes.
That fear dynamic.
Exactly. And maybe also, how do we, as people trying to understand these complex situations, navigate it all? How do we try to discern truth when we have conflicting narratives, strong denials, and sometimes very strong opinions swirling around in the public conversation?
Difficult questions. No easy answers.
Definitely not. But important things to think about as this case, and others like it, continue to unfold.